This is Michael Popok, Legal AF. The New York Attorney General wants Donald Trump and his lawyers gagged again, re-gagged, by the appellate court responsible for all things that happen in Manhattan, the Appellate Division, First Department, with a new raft of filings by the New York Attorney General, not just a brief, but declarations and affidavits from courtroom personnel talking about how they, the principal law clerk, the judge, and others have been mercilessly attacked, violently attacked by followers of Donald Trump in a classic stochastic terrorism call and response. Donald Trump to his people, he calls for them to do something violent, and they do something violent, including leaving assassination threats on the voicemails of the judge and the principal law clerk. This is the obvious byproduct and purpose of the lawyers for Donald Trump having already made their record to the appellate court about what they think is an improper relationship, professional, between the judge and the principal law clerk. They think she's some sort of co-judge, that she's some sort of Democratic operative. They've made that argument. It is preserved for appeal. That's what we call it. You don't get to keep raising it over and over again in a meritless, frivolous, unprofessional manner, time and time again, just to disrupt the decorum and dignity of the process. The administration of justice needs to be protected. And the New York Attorney General, quoting cases from the 1870s in New York, remind the appellate division and the 5 judges that'll be hearing this issue that it is important, and the judge has the inherent authority and power to control his courtroom, the administration of justice, and to regulate the speech of participants in that process, whether they be defendants, plaintiffs, the New York Attorney General, lawyers, and the like. And that First Amendment rights yield to the proper administration of justice in a civil setting, especially in a civil setting. And that on that balance, it's no contest. Donald Trump has violated every rule of decorum and dignity and civility in that courtroom, and so has his lawyer. So have the lawyers. They could be those lawyers, Alina Habba, Chris Kice, Cliff Robert, and I'm a member of the New York Bar, could be sanctioned by the New York Bar for what they're doing. Alina Habba, for those that aren't members regularly of the New York Bar, and they're there by special permission, they could have their special permission pulled. They could lose their ability to practice law in New York, and for this case. And I think every time you see judges say things like unprofessional, and in the filings of the New York Attorney General, unprofessional actions of the lawyers, that's code for New York Bar, First Department, which regulates lawyers in the First Department, which Manhattan sits in. Take a look at their conduct. I think that's an invitation to do that. The judge could also make a referral related to what he sees as unseemly, unprofessional conduct in the courtroom. Let me read for you a couple of really bombshell items that are both in the papers that were just filed, the opposition to the motion to stay the gag order by the Attorney General, attaching all of Donald Trump's postings and comments and transcripts of ridiculous attacks, disgusting attacks, misogynist attacks and racist attacks on Letitia James, the New York Attorney General, the principal law clerk, leading to a affirmation, which is a form of affidavit filed by Charles Holon, who is the officer or captain of the Department of Public Safety assigned to the Judicial Threats Assessment Unit of the Department of Public Safety. That's the group that makes sure judges and their staff don't get killed. And they are assessing it. And I'll read to you some devastating information contained in there that should be a sobering wake-up call for this appellate court to overturn a temporary decision by one of its members, Justice Friedman, and reassess his decision to put a temporary stay in the gag order and reimpose the gag order ASAP. Let me read a couple of pertinent provisions. I won't, of course, read for you. You don't pay me to read for you the 40 pages, but let me read you from 4 or 5 paragraphs that'll bring the point home of what they're trying to accomplish at the New York Attorney General and how seriously they are taking it. In paragraph 29 of the filing, which is on page 11 over to page 12 of their filing, this is what the New York Attorney General said to frame the issue. Since this court's grant of an interim stay by that one judge Mr. Trump has engaged in a number of personal attacks against Supreme Court's principal law clerk. That's the trial level in New York, the Supreme Court, on the Truth Social social media platform. For example, on November 16, just several days ago, he posted that the court's politically biased and out of control Trump-hating clerk, who is sinking him and his court to new levels of low, is a disgrace. 2 days later, he reposted Trump an online article that the principal law clerk, suggesting that the principal law clerk engaged in drug use. Let me repeat that. Pardon me. He's accusing the law clerk in a defamatory way, and lawyers are letting him do it, which is a violation of their oath as bar members. The principal law clerk is being accused of drug use in social media by the former president of the United States. In yet another post, Mr. Trump lambasted the, quote, crooked and highly partisan law clerk and stated that she should be sanctioned and prosecuted over this complete and very obvious miscarriage of justice. And then they went on to say on page 12, just yesterday, Mr. Trump again attacked the horrendous, seething with anger law clerk with her illegal campaign contributions. Now, by the way, that's all BS. All the law clerk is doing is her job. She's handing notes to the judge. She's consulting with the judge. She's conferring with the judge. The judge makes the ultimate rulings as the judge. She's there to assist him to go through 7 weeks, ultimately 10 weeks of trial testimony, thousands and thousands and thousands and thousands of exhibits, dozens and dozens and dozens of testimony by witnesses to keep it all straight, because the judge is the trier of fact and she assists the judge, as do all the staff, as the trier of fact. There's no jury. Now, that's on paragraph 29. On paragraph 61, listen to this. That's on page 27 over to 28. In addition, as noted in this high-profile trial, the Supreme Court has been flooded with hundreds of harassing and threatening phone calls, voicemails, emails, letters, and packages. There is a paramount interest in protecting the court's staff and the functioning of the state's judiciary, especially in the overheated environment in which the trial is taking place. Indeed, any actualized threat against the court staff would have dangerous ramifications for others. It would endanger security personnel charged with protecting the court and counsel, the news media, and the public, all of whom are present in the courtroom. Paragraph 62 on page 28. Notably, petitioners' free speech interest here, Trump, if any, are vanishingly slim. As explained, litigants and their attorneys do not have unfettered rights to attack the integrity of trial participants during an ongoing trial. And the exceedingly narrow scope of the October 3rd and November 3rd orders means that at most those orders have only some minimal effect on petitioners' speech rights. Now get this. Listen to how long-standing the law is in New York and in other places of the inherent authority of the judge to make sure that decorum, dignity of the process is always maintained. On paragraph 73 on page 32, the New York Attorney General tells the appellate court, moreover, to ensure their proper functioning, courts, quote, are universally acknowledged to be vested by their very creation with power to impose silence, respect, and decorum in their presence and submission to their lawful mandates, and as a corollary to this proposition, to preserve themselves and their officers from the approach and insults of pollution. That is a case that dates back to 1821 in New York. That's how long, at least, a court, the highest court in the highest court in New York, the Court of Appeals, in 1821, ruled that in a case called Anderson versus Dunn. It was reaffirmed, as it often is, in a 2014 case called SAS versus Cohen. Listen to those words and compare them to the conduct you're observing by Donald Trump in all of the courtrooms and courthouses. Judges are universally acknowledged to be vested by their very creation with power to impose silence, respect, and decorum in their presence and submit to their lawful mandates, and as a corollary, to preserve themselves and their officers, meaning their staff, from the approach and insults of pollution. This inherent authority, the brief goes on, which has been recognized in New York for over a century, includes, quote, all powers reasonably required to enable a court to perform efficiently its judicial functions, to protect its dignity, independence, and integrity, and to make its lawful actions effective. Everything that Donald Trump has done, and I'll read off for you in the declaration from the peace officer, all the things Donald Trump has done has been to undermine independence and integrity of that court, its dignity, and make its lawful actions ineffective. That's what his goal is. And so any reasonable appellate court, there should be at least 3 votes to reimpose the gag order and to reassert the precedent and the power, not just for this defendant, but for all defendants, that trial judges in New York have the power to use appropriately surgical gag orders in order to preserve the integrity of the process and protect them and their staffs. That seems to be basic rights, basic human rights. If there was a Bill of Rights for courts and courtroom staff, I would think that would be in the top 2. And to Donald Trump's lawyers, just a personal point here. Speaking to them, turning to the camera, as they say. Grow up, be professional. You're officers of the court. You should be ashamed of yourselves. I'm a member of this court that you're attacking on a regular basis. I was admitted in this court in 1992. I practiced regularly before this court. I may not agree with all the decisions that are made, but I don't challenge the integrity, the competence, the character of any member of it unless I have good cause. You do not have good cause to do any of these things, and you're risking your bar licenses and your ability in the future or at present to practice law in New York. It's a privilege, not a right. Treat it like that. They are beating up a principal law clerk who is also a member of the bar and potentially and likely a member of the court as a judge in the future because she's running for office. And your legacy as lawyers, Alina Habba, Chris Keiss, Cliff Robert, most of which we've never heard of until Donald Trump hired you as the 3rd string replacements for his last 3 sets of lawyers that he all fired or they got disbarred or they got convicted or indicted. You know, you have precedent to follow here. You saw this movie already and what happens to the people that you replaced. You're not the first set of lawyers Donald Trump has used in these cases. You're like the 3rd or 4th string. And you know how this ends. Save yourself. Be professional. I was taught early on in my career, don't mistake being a zealous advocate required by our bar rules and professional conduct with crossing the line into unethical conduct because you want to help your client. If at the end of your presentation in a criminal case, the justice system and the jury and the judge sends your person to jail, don't you follow right behind him. The client always goes to the metal door, and you as a lawyer, you head out the wooden door. And there's this confusion. There's this Trump fever that overtakes the professional judgment of lawyers. And it's embarrassing to watch. And thank God the New York Attorney General is calling it out. Speaking of calling it out, wait till you hear what the chief peace officer or the captain in the Department of Public Safety for threats against the judiciary and its staff has to say in his filing. So here's what he had to say in his affidavit. He says these were a series of things starting on October the 3rd of 2023, right around the time of the gag order. The threats, harassment, and disparaging comments increased exponentially and were now being directed at the judge's law clerk. Specifically on October 3rd of 2023, this is paragraph 5 of Mr. Captain Holland's declaration. On October 3rd, 2023, Mr. Trump posted to his social media account a picture of Allison Greenfield with United States Senator Charles Schumer with the added caption, "Schumer's girlfriend, Allison Greenfield, is running this case against me. How disgraceful. This case should be dismissed immediately." Although Mr. Trump did not directly threaten Miss Greenfield, The comments made in his post resulted in hundreds of threatening and harassing voicemail messages that have been transcribed into over 275 single-spaced pages, and he attaches them. Miss Greenfield's personal information, including her personal cell phone number, email addresses, have been compromised by daily doxing. She's been subjected to on daily basis, harassing, disparaging comments, and anti-Semitic tropes. I have been informed that she's received 20 to 30 calls per day to her personal cell phone and 30 to 50 messages per day on her social media accounts. And that since the orders have been lifted, the gag orders, approximately half of the harassing and disparaging messages have been anti-Semitic because she's Jewish. The threats against Justice Engoron and Miss Greenfield are considered to be serious and credible and not hypothetical or speculative. That's paragraph 8. In order to provide this court, the appellate court, with the seriousness of the threats being made against Justice Engoron and his staff, below is a representative sample of the hundreds of threats, disparaging, harassing comments, and anti-Semitic messages that are directed at the judge and his staff. And then there is a listing, which I'm not going to, I don't want to give any more publicity to the statements, but let me just summarize them this way. They're pornographic, they're misogynist, they're racist, they're sexual, abusive sexual. They're threatening assassination, hanging, they are body shaming, they are gender harassing, and the like. If you just sum them all up, I'll just show you what the single pages look like of the transcript that runs 275 pages that were attacked. And that's the call and response to the stochastic terrorism that we see time and time again with Donald Trump. This is why the Appellate Division First Department, based on this evidence that's been presented, has to re-gag Donald Trump and his lawyers, not from talking about the case, not even from talking about the judge, from attacking staff. And shame on them that they would even oppose or make effort to continue to attack the principal law clerk and the staff in their way, knowing now of the threats that have been made against all these people. They like to say, well, we're not responsible for what all the crazies do out there. They made an argument at the D.C. Court of Appeals just yesterday, earlier in the week, to try to argue against the gag order there. When one of the judges raised with the advocate for Donald Trump, what about the person that left an assassination threat on Judge Chutkin's voicemail? Oh, he can't be responsible for that, Your Honor. She's a crazy lady. She's a crazy lady, lives with her parents. She's bipolar. Can't be held responsible for her. Is that the excuse for everybody? Everyone who picks up a gun, a weapon, attacks the person that was hunting Barack Obama and his family, that was stopped by the Secret Service in his neighborhood in Washington, D.C.? That's no responsibility, no blood on Donald Trump's hands. He can just say anything he wants with impunity? I don't think so. We're going to see the response from Donald Trump in the coming days. It's timed out to be fully briefed by the 27th of November, at which time the appellate court will hold oral argument, and we will likely be able to hear the oral argument, at least an audio version of it, and comment on it on Legal AF, the leading podcast at the intersection of law and politics and justice, only on the MeidasTouch network. Free subscribe, help MeidasTouch get to 2 million free subscribers. If you like this kind of content, I do it about every hour, if not every day, and also on Legal AF, our curated podcast on Wednesdays and Saturdays at 8 p.m. Eastern Time, and then on audio podcast platforms wherever you get them from. Leave me a thumbs up, helps with the ratings, helps keep this content coming to you. So until my next Legal AF, until my next hot take, this is Michael Popok reporting.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.